Welcome back to Talk of the Town on 99.7, 1450 WHTC and WHTC.com.
And we welcome you back to Talk of the Town for this Thursday, May 13th. I'm Gary Stevens. Thursday mornings, the second Thursday of the month. This 9:30 segment is titled Ask the Judge, where we have either a member of the 58th District Court as a judge or as a, will be in a moment, a magistrate, or a member of the Ottawa County Prosecutor's Office to answer your questions, mostly about criminal law, but also some, sort of a look behind the screen and look at what a man and woman does with the robes. As always, the caveat is that we really can't talk about individual cases, but we can talk in generalities about criminal law and the courts itself. And today we are joined by 58th District Court Magistrate Vern Helder. He joins us from the courthouse and via the Zoom connection. Vern, good morning. Welcome back to WHTC.
Good morning. It's good to be back.
Glad you are with us. And if you have a question for Vern Helder, we'll take it at 616-395-1450, 616-395-1450. This is a little bit of ground rules, just sort of a reminder. We are chatting with Vern. And in respect to Vern, if you have a question for him, we'll take it now. If you have a general open line comment or question, we'll take it after the 10 o'clock news. And of course, we are in an 8-second delay. So please turn down your radio before you chat with us, and we'll be happy to include you in the conversation. Let me remind, or have Vern remind people, exactly the duties of a district court magistrate. This is a good time as any to sort of refresh people on what exactly a magistrate does do.
Well, I'm glad to let people know. We, as magistrates, we're not elected. We're appointed or hired by the judges, and we fill in or take some of the responsibilities that the judge would have if they didn't have a magistrate to free up the court docket for the judges. So as magistrates, we do primarily traffic ticket hearings. So anybody that's issued a traffic ticket and wants to fight the ticket, they would first come and see the magistrate. That would be an informal hearing. As an attorney magistrate, I do all of the small claims cases, and I do those for the 58th District Court. And we have 3 court locations: Hudsonville, Holland, and Grand Haven. So I am fortunate enough to be able to travel to all 3 different court locations. We do search warrants and arrest warrants, just like the judges do. An officer or detective will come and find either the magistrate or the judge, and then we review the search warrant, for example, and if there's probable cause, we'll issue the search warrant. We are also on call in rotation with the judges, so once every 7 weeks I am on call, and what that means is any warrants that are required after hours, we get called, and then we have to go to the jail on Saturdays and Sundays and set bond for those that have been arrested.
So basically, you're sort of helping the judges, sort of as I wouldn't say auxiliary, but you complement the judges in their work.
Yeah, I would say that's an accurate description. So
now, qualifications for one being a magistrate. It's not necessarily you got to have a law degree in order to do this, as we have seen with some of the other magistrates who've had more of a law enforcement background than an actual legal law background.
Right. So in Michigan, there still is not a requirement that you have a law degree to be a magistrate. I think there is a tendency to lean that way, but I can tell you in my experience with the magistrates that I've worked with, those that have law enforcement backgrounds, it's a very valuable background to be a magistrate. So you can imagine as a police officer, you've dealt with traffic issues, you've dealt with criminal issues, and a lot of those things are the same or similar types of cases that come before the magistrate. Now, the one critical thing or the one important thing that a non-attorney magistrate may not do is he may not do small claims cases. So that's why I handle all of the small claims cases in all 3 locations, because I have a law degree.
Okay.
And I guess that makes sense, right? Because there are many, many different issues that come before the court. Those are civil cases, obviously, and a lot of issues come before the court where a law degree does come in handy. So
All right. If you have a question for Magistrate Vern Helder, 58th District Court Magistrate Vern Helder, he'll be happy to answer it at 616-395-1450, 616-395-1450. Let me talk a little bit about small claims court and dealing with small claims, because you are dealing, for the most part, with individuals who don't have a legal background, or shall we say cannot have legal representation. That's part of the rules of, I believe, of a small claims court, is that you cannot be represented by legal counsel in small claims. So you're dealing with people that maybe aren't as, shall we say, well-versed in the courtroom etiquette and the courtroom laws. Does that make it a little bit more of a wild, I don't want to say Wild West, but a little bit more of a uncertain air about it? When you do have actual lawyers and who've been through a few courtrooms in their time, they sort of know what they can do and not, what line they can cross. When you're dealing with people, with a lot of emotion, sometimes that line can be crossed pretty fast.
Yes. So in small claims case, you may not have an attorney and you may not have a jury trial. So those are the two rights that you give up to have your case in small claims court. And then there's a jurisdictional limit. So right now, the maximum amount that you can sue for in small claims is $6,500. The maximum amount of a general civil case in district court is $25,000. If you're over $25,000, then you would go to circuit court. But really, a lot of the issues are the same in a civil case, whether it's a claim for $10,000 or a claim for $6,500 or less. A person then might choose to go to small claims court because they either don't want to hire an attorney. The small claims court is actually a more efficient manner to get your case heard. We schedule cases, I think, around 45 or 60 days after they're filed for a hearing. And that's a much quicker process than if you went to the general civil division of the district court. So the small claims division is just a division of the district court. So either in small claims division or you're in the general civil division. But the biggest difference is you may not be represented by an attorney. So we do have people come in here, and as someone who practiced in front of the court for 18 years before I became a magistrate, I understand the court system. I understand what the rules of evidence are. And I also understand that if you don't have that experience or legal background, you're not necessarily going to be able to present your case the same way that an attorney would. So we still have rules of evidence. We still have to abide by the rules of evidence, but we're a lot more relaxed as far as being very technical with them. For example, somebody that comes in and wants to tell you what someone else said about their case. Okay, that's hearsay, right? It's using the statement that someone made out of court for the purposes of proving the truth in court. What I do is I will allow people to bring or introduce evidence. It can be a written letter. It can be a notarized letter. It can be a letter that's not notarized. And I will give what I think is the appropriate weight to the evidence. So I look at all of the evidence. I don't make them adhere strictly to the rules of evidence because they're not attorneys. They don't know what the rules of evidence are. And the purpose is, or the objective is, to allow someone to have their day in court. So it does get a little challenging, but one of the biggest issues is there's a lot of the times the parties have personal vendettas against each other. And so it does become very personal, but I take it as something very serious. I understand that this is very important to them. And so I want to give them their day in court.
616-395-1450. Good morning. You're on the line with Magistrate Vern Helder.
Good morning. This is very timely. I just left the 58th District Court where I used your terminal to find the address of a guy who I want to serve for a small claims appearance. And I'm on track now. But the question that comes up is that my small claims is originating from a traffic accident whereby under Michigan law, if somebody does not carry collision insurance under the mini tort system, they're able to get up to $3,000 per the most recent insurance reform in 2019. My question is, driving an older car in excellent condition, and it sustained I'm going to say it sustained $5,000 worth of damages, and that's what the collision shop charged to put it back together. Will the court look at the blue book value and say, "Oh, this car is only worth $2,000, so we're not going to give you $5,000 to repair it"? Is that is that correct? Or I'm out of pocket $5,000. Does that make a difference in small claims court what it's to repair?
All right. Well, you can listen to offline for that answer. Let's make it in general terms, not particularly in the specific terms, because we really can't do that in a specific case. But in general terms, when a claim is made, do you have to sort of weigh the issues on that?
Sure. Well, first of all, I want to make sure that the listeners don't think that I'm ruling on a case, because if he's filed a small claims case and it comes in front of me, I don't want someone to think that I've heard all of the evidence before I've predetermined what my decision will be. So I will answer in general terms. So the Michigan mini tort statute was recently amended, and you may now sue for up to $3,000 in damage to a motor vehicle not covered by insurance. If the other driver didn't have insurance, they have to have the minimum insurance in Michigan. It doesn't have to be collision coverage, but you can recover up to $3,000 against the driver who has insurance, and that's for damage to your vehicle. If the other driver didn't have insurance, they're not covered by the mini tort limit of $3,000. So you could sue for more than $3,000.
Now, but let me backtrack for a second. I think the crux is, can you file litigation for actual cost or evaluated costs?
So if you have damages that are a result of an automobile accident and the other party's at fault, you can recover those damages up to $3,000 not covered by insurance. But I do look at the facts of the case, and if there is a vehicle that's only worth $1,500, but there's damages that were totaling $8,000, of course, they're not going to fix the car, but I will give them what it costs to replace the car, not what it costs to repair them if they chose to repair the car. So I look at what the value of the car is, and circumstances may be different. If you have a collector car, or if it's a car that you choose to repair, and you've got those expenses, that may be different. One thing I've learned over the years is never make a ruling, or even in my mind, a determination as to what the result is going to be until you hear both sides. So obviously I would need to listen to both sides of a case before I could make a determination. But yeah, it all depends on the circumstances.
616-395-1450, 616-395-1450 if you have a question for 58th District Court Magistrate Vern Helder. This is probably not in your province, because it more often than not, it is handled by the district court. And that is matters involving landlord and tenants. Mondays usually is the day for such adjudications. More often than not, the landlord is represented, the tenant is not, which can cause some issues. But do you get a sense that as we move out of the COVID-19 restrictions we've had, and part of those restrictions was the prohibition on evictions, do you get a sense that perhaps the court's going to be pretty busy, if it isn't already, with landlord-tenant situations, because the tenants, frankly, cannot afford to keep up their rent?
Yeah, so we do not handle, as magistrates, we do not handle landlord-tenant matters as far as evictions are concerned. I do get involved in landlord-tenant issues in small claims court with respect to damages, but that obviously is not the eviction process. It's after someone leaves and there may be damages, or someone doesn't get their security deposit back, they can sue for that. But yeah, I would imagine, we've been kind of postponing, if you will, some landlord-tenant matters. So I would imagine that the courts are going to get a little busier with landlord-tenant issues. And I know that our chief judge, Judge Canal, has dealt a lot with that. because there have been changes frequently as to, what we can do and what we cannot do in landlord-tenant matters. So there has been a moratorium on evictions, and I'm not sure exactly where that stands at this point. But
Yeah,
I would imagine we're going to get busier.
yeah, I'm just thinking, and again, I'm more thinking along the lines, not so much of professional tenants, of professional landlords, people, corporations that own maybe one, two, or even more units or apartment complexes. But I'm looking like, say, for someone who might be renting out their home, and individual landlords. It's been kind of tough for them because they're not the big corporations, but yet, they can't kick somebody out because they're not paying.
Yeah. But I do think there's a lot of rent assistance programs that have become available, and so hopefully that helps landlords out.
616-395-1450. Let's get one more call before the break. Good morning. You're on the line with Magistrate Vern.
Oh, good morning, Mr. Stevens. Good morning, Magistrate Helder. You're a wonderful person, a great judge. I voted for you last time. Could you talk about the end of chattel slavery in 1865? I understand that there's something called legal slavery, involuntary servitude. There's some kind of allegations that's been done here in Ottawa County to get free cheap labor and using the court system for cheap labor. They call it involuntary servitude. I wonder if you could talk about that. Thank you. Have a good day.
Thank you very much for the call. Yeah, this is he's bringing up something that's 170 years old, I think, more than anything else.
Yeah, I'm not sure what his question actually is, and so I'm not really sure how to answer that. I'm not aware of any involuntary servants or servitude, or whatever the term was. So I don't know if he's got more, if there's anything more specific, but I wouldn't know how to answer that question.
Yeah, let's put it this way. We thought we put that to bed in 1865, but sometimes you have some lingering matters, and of course, a topic that probably is for a different segment, and not with your segment, is dealing with the human trafficking issue. And again, judges have to deal with that, and that has become a societal problem as well, with the human trafficking. And sometimes you can use those servitude rules and laws to try to stop them.
Yeah, well, there is a big problem with human trafficking. I think it's bigger than a lot of people really realize. So, I'm still not sure how to answer that question.
Okay, sounds good. Vern, as health restrictions become more relaxed, as more and more of us are getting vaccinated, and the concerns about COVID-19 are starting to die down, operations at the court, especially in your auspices of small claims and other matters, how much of it can still be done in person? How much of it can be done online? Is it starting to go back to the in-person work that we had before last March?
Yes, we are handling most of our cases in person. So if you're a party to an action, you may come into court and have your case heard in court. We do still do a few of them via Zoom. It becomes a little cumbersome to do a small claims hearing, for example, by Zoom, because if people have exhibits, it's hard to exchange those and review them. But we have been doing in-person hearings for quite some time. We do limit the amount of people that are in a courtroom at any time. So there can be no more than 10 people in a courtroom at any given time.
Now, when, for example, when somebody has an issue, say, with a traffic moving violation, and they say, hey, listen, hypothetical situation, all right? I'm driving. I have my cruise control set for 55. On my vehicle, it says 55. I get pulled over, and the deputy will say, I have you clocked for 62. Wait a minute. That's not small claim. That goes before the magistrate, because it's a case of, hey, deputy says one thing, my vehicle says another. Is that really for your side?
Right. So, so the deputy has the burden of proof in a traffic hearing. ticket. So the burden of proof is a preponderance of the evidence. So it's different than a criminal matter where it's guilt beyond a reasonable doubt. So the officer would have to testify as to how he determined that was the vehicle that was speeding. What type of device did he use to detect the speed of the vehicle, whether it was a radar instrument, a laser instrument, or did he pace the vehicle? So pacing is when you drive behind a vehicle for a period of time and try to match the speed of the vehicle. Police cars have calibrated speedometers, so they should be very accurate. And so it just depends, what the testimony is. But then, the respondent would have a chance to respond, and then the court would make a determination based on the evidence presented. So a preponderance of the evidence means, is he more than 50% right? So it's just that the balance of the scale, if you will. So sometimes those can be challenging as well. But it just depends. The officer does have the burden of proof, and we do listen to both sides before we make a ruling.
Yeah, if I would have to go to my, I got something from my mechanic saying that my speedometer was calibrated properly, and then it's a case of, okay, do you believe one side or the other? And again, preponderance of truth. And it used to be the old days, and I don't know whether or not it's still done. You would see markings on the roadway, and say you see a little stripe here, and then maybe about a quarter of the mile down, you see another stripe on the roadway, and you kind of wonder, okay, what's that for? Actually, it's the bird, the police bird in the air, and they're judging how fast you go between point A and point B. And if you're going this, if you clock it at this amount of time, you're fine. If you clock it a little bit faster, you're getting pulled over. And 10-4, we got to get that, that car down. You don't see it too much. I think the last time I saw it was on US 23 in Ohio. And they used to clock people, all these Michigan people driving down to Columbus for the Michigan-Ohio State game. And that used to be a speed trap as well. 616. Yeah, go ahead, Vern.
We don't have those in Michigan that I'm aware of. So and none around here anyway, in Ottawa County.
Okay. Yeah. Well, sometimes some of the old ways of catching scofflaws driving around. How can people get, I want to say help, but in terms of contacting the district court, whether or not it is something that the court can handle or they have to do that, especially with the small claims, how do they do that?
So we have small claims clerks in each location, Holland, Hudsonville, and Grand Haven, and you may contact the court and talk to the small claims clerk, or you can talk to any one of the counter clerks. They're very, very helpful. The one thing is they cannot give you legal advice. So they can't tell you whether you got a good claim or a bad claim, or whether you should file your claim. They can't tell you who to sue. They can't tell you, how you should fill your paperwork out. So, but they are very helpful, and they know a lot about the process, and they know a lot about the, small claims case, for example, or traffic ticket, for example, and they can tell you what your options are. And so the best thing to do is contact them. They're very, very helpful. They're very knowledgeable, and they're willing to discuss that with you.
58th District Court Magistrate Vern Helder, I want to thank you very much, as always, for your thoughts and some time to chat with us on WHTC's Talk of the Town. Wish you and everybody at the court well, and look forward to chatting with you again soon later on this year.
Thank you. Thank you for having me. It's been my pleasure.
Thank you very much, Vern Helder, on 99.7 and 1450 WHTC.